All right. I will now call the Select Board meeting to order on February 27th for 5:32. If you can please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. So a continued public hearing will be held on Thursday, February 27th, 2025 at 10 West State Street, Granby, Mass. To consider a gravel permit application by LJ Development, LLC. Applicant and owners, James and Kathy A. Slate, ETAL 44 Mercier Drive, Belchertown, Mass. To remove earth materials from property located on Trompke Avenue. As per the zoning bylaws, Section 5, Special Use Regulations and Performance Standards, 5.8 earth removal of the town of Granby. So we will start first if the applicant can come up and address the
Could you address your attorney first?
Sure.
My attorney couldn't be here.
Okay, yeah, absolutely.
And they've been talking, and so he
Yeah.
put in a request, and I'm not a lawyer, so I don't even
Yeah.
know what's going on.
No, I totally understand that. But I am going to ask, because GCAM's having a hard time hearing at home, if when you do
that's fine.
speak, you can come up to the front. Thank you. So Attorney Costa, if you can just let us all know what the letter said.
Sure. So as you had announced, tonight was intended to be a continuation of the public hearing on this application for a gravel permit, gravel special permit. We've had a number of meetings thus far. Special permits require public hearings as a matter of state law. This is not something that's unique to Granby. A public hearing for a simple project can be open and closed and maybe even voted upon in a single evening. But other projects, more complex projects, often require public hearings that are continued from time to time over a series of public hearings. And that's what has occurred here. I think you've had 5 or 6 of them. I don't know the exact number because they actually predate my involvement in the matter. Something that I became aware of only maybe 3 or 4 weeks ago was that prior to me being engaged as special counsel for the board, and in fact, I believe even prior to Attorney Berthium being engaged to represent the interests of the applicant, there were a couple of initial meetings, initial sessions of the public hearing convened and conducted by the board without the same membership on the board as exists today. One of your members was not a member at the time for 2 or 3 sessions of the public hearing. That's problematic because the law requires, and has long required, that to be eligible to vote, you attend every session of a multi-session public hearing. Now, a number of years ago, there was a statutory amendment made that allows, if your community has adopted the amendment, and Granby has, that allows members of an adjudicatory body to miss one session of a multi-session public hearing and to review the video or to review a transcript of that session and to sign a certification and file it in the record, and then preserve his or her qualification to vote. The problem is that statute is limited to one session. As soon as a member misses a second session, that member renders him or herself ineligible to vote on the application. Now, sometimes that's a non-issue. This problem arises with some frequency with respect to projects that are reviewed over an extended period of time. Not much of a problem with a 5 or 7 member board, even if the application requires a supermajority vote. If a member becomes ineligible, there may still be a sufficient number of remaining members to vote on the application. Well, the problem here is this is a special permit. And the law says for a special permit, a 3-member board can only approve that special permit by way of a unanimous vote. So all 3 of you would need to vote in favor of the special permit for the permit to be granted. There's no practical way that can occur because not all 3 of you are eligible to vote on the application. So I made Attorney Berthium aware of this issue. I told him that in my experience there are a few different ways, and I shouldn't say I told him, I suspect he knew it because this is not his first rodeo either. But there are a few different ways to get around or to resolve this issue of ineligibility to vote. But the most common way is to reconstitute the board, and that's terminology that we use. You won't find it in any statute. But essentially what it means is you renotice the public hearing as if it were starting from scratch, because of course, those who are attending in your audience today, they haven't been getting mailed notice of every session of the hearing. They got a mailed notice of the first session, and then you've announced your continuances. Well, by reconstituting the board and renoticing the public hearing, you're essentially starting from scratch, and therefore you're rendering all members at that first new session as eligible to vote on the application. That might make some sense if the applicant were ready today or anticipated being ready in a couple of weeks to proceed with the application. It might also be appropriate if there was a belief that the current membership of your board was going to be stable over the course of the next 3 to 6 months, or however long it might take for there to be a couple or 3 more sessions of a public hearing. I don't think either of those things are true. We have received the reports that, or all of the reports that the board had requested a number of months ago, which we had anticipated receiving in advance of tonight's meeting. I also understand that you have a seat that will be up for grabs in the annual election in May, and that the incumbent may not be running for re-election. I don't know if that's the case or not, but there's no certainty there. So as a consequence of all of that, what I suggested to Attorney Berthiaume was the appropriate thing to do would be to withdraw the application and to reapply at such time as, number one, his client is ready with the relevant information, documentation, reports to actually prosecute the application, to advance it before the board. And number two, at a time when he believes the membership of the board is going to be stable for a period of a few months, to allow those reports to be reviewed, peer reviewed, and ultimately for the board to vote on the application. So as a consequence of those discussions, which have occurred over the course of the past week or so, we received a letter yesterday from Attorney Berthiaume asking for a withdrawal without prejudice. That last phrase, without prejudice, simply means that, and it's a bit odd in circumstances like these. It's a terminology that the courts use. All it means is that there is no prejudice to preventing you from making application again in the future. The law says that applicants are entitled to request withdrawals without prejudice from special permit granting authorities like your board in this instance. But that once the public hearing has been noticed, and in this case gotten underway, it's been underway for quite some time, that withdrawal can't be done unilaterally by the applicant. It requires a vote of the board. So that's where we are.
Okay.
I'm confused. Question. There's without prejudice, and then there's also another option.
There is another option, right?
What's
Attorney
the other
Costa?
option?
There is. So the obvious sort of corollary to without prejudice is with prejudice. With prejudice would have the effect of preventing, in the zoning context anyway, it would have the effect of preventing a reapplication within a period of 2 years. Because essentially a withdrawal with prejudice has the same force and effect as a denial of the permit. So that would be the alternative option. I will say, because I think it's important, I don't generally see withdrawals. In fact, I can't remember having ever seen, I've been doing this for 19 years, having ever seen a withdrawal with prejudice. Because if an applicant got the sense, and in fact, Attorney Berthiaume's letter says it, if an applicant got the sense that a board is going to withdraw only with prejudice, they would rescind their request to withdraw, and they would either opt to proceed and take their chances with the denial on the merits, which they would then appeal if they were dissatisfied with it, or they would simply prosecute with the intent of ultimately obtaining the permit. Or I suppose they could challenge the withdrawal with prejudice as an effective denial, which in my experience would simply result in the court remanding it to the board to gather additional information. So I don't know that a withdrawal with prejudice makes sense in this case. And again, if you look at the letter that was submitted by Attorney Berthiaume, he explicitly states that he's asking for a withdrawal without prejudice, and if the board is not inclined to grant that, then he asks for a further continuance to reconstitute the board. But He's only going to reconstitute the board to allow him to appear before the board again in 4 to 6 weeks, I would say, only for him to continue the process to maybe have to reconstitute the board again after the annual town election, which didn't seem to make much sense.
No. Okay. Mr. Jackson, do you want to come up? Did you have anything you wanted to add to that?
Yeah, well, this,
Okay.
yeah, one thing. I'm Neil, excuse me, I'm Neil Jackson, one of the owners of LJ Development. I think one of the requests by the board is a particulate study. And we've tried unsuccessfully to get anybody to even give us a scope of services because they don't know what the board's requesting. I reached out to the town administrator, Chris Martin, before he left, and he gave me a couple names of engineers, and I contacted both. They don't do it, so I sent a letter requesting any engineers that Kathy Leonard was aware of, and which she forwarded the request to your attorney. And, you know, it's common practice. I think he was upset that we were asking for any and it's not really a recommendation. We were just asking for a list of any professionals that do that type of work, and that's very common. I'm an engineer, and I request lists of professionals in conservation meetings and Board of Health meetings of people that do work that I don't do. So I was doing a job for an engineer from Ty and Bond, and I asked him, and I think they have 800 employees now, so they're probably the biggest engineering firm in the state. And they basically said they cannot provide a scope of services because they have no idea what the board's asking for. So they need clarification too. So I don't know who they would talk to, if they talk to the Selectboard or the attorney for clarification, but they don't know what the board's asking for.
So from my understanding, the particulate matter in the air is when the gravel pit is being used, what debris is going to be in the air and how far is it going to travel. So that to me is the scope. And Attorney Costa, if you want to clarify, because you've been part of this before with particular matter.
So that was my understanding. I mean, this was
Mm-hmm.
terminology that the board adopted in referring to particulate matter. But I think ultimately, and again, I don't want to speak for your board, but I think ultimately what it was that the board was seeking was essentially some confirmation through a qualified consultant that the air pollution generated by this particular project would not have adverse impacts on the health or the quality of life of nearby residential homeowners. They weren't going to see consistent dust in the air that they would be breathing in and choking when they're in their backyards having, barbecues in the summertime. So I don't know, again, the terminology the board chose was particulate matter. I don't know that if you go to Ty and Bond's website, for example, you're going to find a link to a particulate matter study, but certainly Ty and Bond, being one of the largest engineering firms in the state, can perform air pollution studies. They do site assessments, they recommend remediation. I've had them involved in projects in which I've been involved. I wasn't upset. I did see that email exchange, and I think I responded either to Kathy or to Chris. And I sometimes email doesn't convey tone, so I certainly hope it wasn't perceived as me being upset that there was a request that was made. I think what I said was something to the effect of, I already recommended to the board peer review consultants on these various topics, and for the applicant to now ask for the town, whether it be through town council or the board or staff, to recommend who the applicant should be using, that's really on the applicant. The applicant's been asked for a study, the applicant should connect with engineering firms. I understand that maybe there was some communication with this terminology, but hopefully if some of these same engineering firms that maybe the applicant has previously contacted are contacted again with this additional specificity using terminology like air pollution, dust, risks to the public health, maybe they'll better understand what it is. I don't think it's a terribly complicated study. It's simply going to evaluate the extent to which this operation is going to create dust in the air, how that dust will travel, and then what possible mitigation measures occur. I see this all the time with routine projects that aren't gravel removal operations, obviously to a much lesser extent, but this is a concern during the construction phase of most every project, subdivisions, multifamily housing projects, shopping plazas, where if you've got a site that is dusty, it has real effects on neighbors. So there are ways where they can use watering trucks, they can keep the dust down, and typically engineers can make those recommendations as part of the remediation that they propose in their reports.
Right. Well, their response was they've never seen a request for a particular study during the permitting process. It's always requested once the permit is granted, to make sure when the operation is actually in effect, what the air quality is at that time. Because the only way they could do it before we have a permit is to do modeling. And modeling is really, you can make modeling do whatever you want it to do, unfortunately. So, a real particulate study would have to be done during the operation of the gravel pit. And that's what they told me, so.
Well, to be honest with you, it makes sense because right now you're asking for a permit to use the pit, but you can't use the pit until you get the permit.
Right,
So how can you know how far the particulate matter is going to travel
right,
if you're not using the pit?
right. I mean,
So when you model it, you would have to go in and dig.
Right.
And
well, they would actually do modeling, but you need the fines in the soil. You need
soil content.
the moisture content. There's a lot of variables that you can keep changing numbers in a computer to get it to spit out what you want it to do. And in actuality, you really want to do it during the operation so you have a realistic number.
And Attorney Costa, have you, is the ones that you've been a part of, has it been modeling that you've seen before they've started the construction or the building phases?
It has. I mean, the
Okay.
challenge with the suggestion that it would be done later is that there's nothing before you later.
Right.
You've issued the permit, and once you issue the permit, you've lost control. Now, there are mechanisms and there are instances where conditions of approval could be crafted if you saw fit to grant the special permit that would require subsequent studies to ensure that appropriate standards are being satisfied. I've seen this done before where there are uncertainties and a board will require certain testing be done. Noise is a good example. So maybe noise modeling will be done, and this is not something you've asked for in the context of this project. I'm just giving it as an example. But if noise were a concern, many boards will require an applicant to prepare an acoustic study. Now that, you can make the same argument. How could we possibly know what the noise is going to be? Nothing's been built yet. Well, because there are resources that can be used, and there's modeling that can be done to approximate what the noise will be. There's on-site ambient readings that can be taken. And then what many boards will do is they will rely upon representations by an applicant that here's the modeling we've done. We are told by our consultants that there's no reason why the decibel level will exceed 45 decibels above ambient. And then you'll include that as a condition of approval, and you will require that 6 months following completion of construction, is a further noise study done to verify that in fact, as was modeled and as was promised to you, the readings do not exceed 45 decibels above ambient. Well, the same thing goes for something like particulate matter or dust or air pollution. I appreciate this argument that the numbers can always be adjusted to spit out, through the modeling process, whatever an applicant is paying for. Well, that's why you peer review these studies, right? I mean, you could say the same thing about studies that are done every day on projects, residential, non-residential projects, traffic studies. Traffic studies are required in more than 50% of the projects in which I assist local boards. Well, how can you possibly do a traffic study if the project isn't built yet and you don't know how many cars are coming or going? Well, because there are third-party resources that can be relied upon. There are manuals that can be be cited to, and modeling that can be done to approximate the number of cars that are generated by certain types of operations based on databases that exist that are to which these engineers have access. So again, I don't know the extent to which the study is going to get into great detail. But I suspect that there is some modeling that can be done. There is some soil study that can be done to determine the moisture content of the soil and how that relates to what is expected in terms of dirt and dust being thrown into the air as part of this operation. But I think that's what the board wanted. Again, this isn't my request. This is the board's request. If you're convinced that this can't be done or shouldn't be done or it's premature, you have the authority and discretion to rescind that request or to require that study be done at a later date. But if it's going to be done at a later date, there needs to be some benchmark that needs to be satisfied, because I've had boards request conditions that say, do a study in 6 months. And then there's a period. That's the end of the condition. Okay, so they do a study in 6 months and the study reveals that it's an absolute disaster and there's dust in the air 7 days a week. Well, you don't have anything before you. At that point, you've granted the special permit. You can't do anything about it. So you need a benchmark and you need some recourse in the event that that study gets done in the future and things don't pan out the way that they're expected to pan out.
Right, and we would certainly be open to a benchmark of what, what particulate matter is acceptable and what's not. And they could probably provide that, what's an acceptable particulate matter in the air, during a gravel pit operation, and then monitor it during the operation. And you certainly can put in there, if we exceed it, you pull our permit. The problem with us using tie and bond, and again, I've developed land my whole life, we never use tie and bond because almost every town in Western Mass uses tie and bond for peer review. So it's kind of hard to use them when the town uses them. But I think they're the only ones that do it.
So I know Attorney Costa had mentioned that there's going to be a change in board members, and there is. I am stepping down from the select board. I'm not going to run for another term.
That's too bad.
So I think I think it would be a waste of time, and this is just me speaking. I think it would be a waste of time for not only you guys but the taxpayers and the select board to reconstitute it now, that because Dave had missed 2 or 3 of the meetings prior.
Right.
And then to reconstitute it again later. I do think that's a waste of everybody's time. So my opinion is to grant them the withdrawal without prejudice. That would be my recommendation, but as Attorney Costa said, I really feel that when you guys are ready to come back, that you need to come back with all those studies. And I know the particulate matter in the air was confusing with the wording that was there. But I think that the modeling, I would urge you, and again, I'm not going to be on the board, so the 3 members that are up here might have a different recommendation. But I would urge you to do that study with the modeling and have it peer reviewed, so there's a starting point. And then, like you said, we can have a benchmark to set from there. And then I know traffic analysis still needed to be done. There was, I think, an ideology one that was submitted at one point, but we still haven't had that peer reviewed, and it wasn't quite a full analysis. And then there was the hydrologic study too. So, I'll let the other 2 board members speak what they believe. That would be my recommendation.
Myself being the one that had missed the meetings, I think it would only be fair to also withdraw without prejudice, to allow you to put things together and move forward down the road if you can.
Yeah, I would agree with both of you. This is something I brought up over a month ago in one of our meetings, actually this exact point, talking about it, that it could become a concern.
Chair, would you take a statement before you have a formal vote in regard to the withdrawal?
In a moment, did you have anything else you wanted to say?
Yeah, could tie and bond talk to a board member or your attorney just to get, so they could actually provide us with a scope of services of exactly what you're looking for.
Be careful, that shifts the burden of responsibility to you for defining that study.
So Attorney Costa, have you ever had that happen before?
So I'll say this. The board is requesting a study, and it is fair for an applicant to want to know the parameters of what that study ought to be, what it is that the board is requesting. I don't think it's appropriate for the board to attempt, or for me to attempt, quite candidly, to play the role of environmental engineer. I heard the board express concerns about things like dirt and dust and air pollution, and the terminology that it chose to capture all of that was particulate matter. That's about the extent of what I'm going to be able to say to whether it be Ty and Bond or any of the other environmental firms in Massachusetts, and there are many of them, that would potentially perform a peer review. So I don't know what more I'm going to be able to offer. It's going to be a different board when a reapplication is made, although it sounds like 2 of the 3 board members will be the same. If either of those 2 board members are willing to have a conversation with an engineering firm speaking for themselves only and saying what their concerns are, I mean, I think it's already on the record. But it's really not, it's for the board to say what it's concerned about and what it wants studied, and how that gets studied and what gets presented to the board. We're not going to define the scope of services for the engineering firm.
Okay. Yep. Jim, did you want?
I would like to.
Okay. Okay.
Thank
Thank
you.
you.
Hello.
Jim Tromke, 290 Taylor Street, co-applicant, representing my family. I've got some concerns here. This is almost 10 months. The board should have notified us 10 months ago that we should have reapplied or what our options were.
Well, the same thing that Attorney Costa said, your attorney didn't know, he didn't know because they both came in later. And we didn't know because we're a part-time board. So once it became,
But where is, I understand that.
Yeah.
We're all a part-time board. I'm a part-time board as I chair the planning board. It's our responsibility to know this. And we should have been notified 10 months ago, 9 months ago, whenever it was. And then we could have started the process then, rather than finding out about it today.
but we still don't have the studies regardless. So we still
Well,
are waiting
that's,
6 months.
yeah, well, that's
It's
a
important.
that's a moot point, because whether we provide the studies or not, we can say we're done with our application.
Okay.
And as far as the air quality, and Attorney Costa mentioned subdivisions. So what subdivisions do when they're being approved is they put conditions that, if you look at the bylaws, it'll state that. So, and I'll just do this in layman terms, that if it's not allowed for any particulate to breach your property. And by doing so, in other words, if there's 10 acres of area that's going to be disturbed for the subdivision, you're not allowed to disturb it all. You need to keep topsoil on it. If you're stockpiling materials, it needs to be seeded, or it needs to have topsoil on it, so that over a period of time, a subdivision may go on for 10 years. And if you've stockpiled materials that become airborne, you have to put either seed it, topsoil, hay, or something. You have to manage that. That's all part of the conditions. So to say we want studies, a study doesn't mean anything. You can say what could happen. The thing is, you put mechanisms in place ahead of time. So if it is happening, whether the study took effect 2 years earlier, there's mechanisms that you have to use to mitigated.
But that's assuming that the applicant knows how to mitigate it, right? So if
It-
you've never
it's-
had a
it's-
gravel pit, it's assuming that you know how to mitigate something that you've never had before.
No, like Attorney Costa said, there's, it applies to subdivisions. It's common practice. You don't disturb soils, a year in advance. You only pull the topsoil off for what you're using in that particular time so that you're not creating more airborne. Or a subdivision, you're not creating a pile of material that's becoming airborne. You cover it, whether it's topsoil, hay, seeding it, whatever the process may be at that particular site. I can't imagine, or I've never heard of anybody asking for that type of a study before on this type of operation.
Well, Attorney Costa has dealt with lots of different projects, and he has, so I'm gonna take him at his word.
That may be so, but I'm telling you, we haven't done that in this town before. Subdivisions, other gravel pits, other operations going on in this town, it's never been asked before.
So you did mention that the studies that we're asking are a mute point. So are you saying that you're not going to come with the studies?
Nope,
and
I didn't
okay.
say that. I'm just saying that it hasn't been requested before.
Okay.
And to me, there's no need to do it. There's a process and a work process that's common conditions for operating a site, whether it's a subdivision or a gravel pit.
But the board did ask you for them in order to grant the special permit, so.
Correct. And
Okay.
as Neil said, Mr. Jackson said, there's been some confusion on exactly what they're looking for because it's not common, even with the engineers. They're like, what specifically are you asking for? And when you go into that kind of detail, usually there's a scope of services you're looking for. And we don't know what the scope is because it's not common practice. And Mr. Jackson asked, what specifically would you be looking for?
Which is the dust, the dirt, and the air pollution. Okay.
Yep. But again, back to what I originally started, why did it take 10 months for us to find out that you weren't, it's like kicking the can down the street. You could do it again. You could do it with the next board. Ask for all these different things and then a couple board members, let's say all three of you are here next year. And one of you decides that you're not going to make 3 meetings. Where's the onus on the town to live up to their obligation for an applicant?
So when you look at the board members, I think there's only one person on this board that's ever missed a board meeting since I've been on here for the last 3 years. I've never missed one.
No, I'm just saying,
I hear what you're
what
saying.
happens, we get a new board next year. We reapply,
It's your
And one-
responsibility.
Rich,
and one board member determines they're not going to show up for 3 meetings, 3 hearings, or 2 hearings. What's the minimum? You're allowed more.
you're allowed to miss one.
So you missed 2. Whether it's on purpose or accidental. Just couldn't do
So I
it.
can't,
So then the process starts all over again. I think that's probably a question for the attorney, but
well, we know. it
there's
was
got to be
turned
some
over.
liability on the town that you have an obligation for the
So-
applicant.
If you had the studies, we could reconstitute the board. It's one meeting, as Attorney Costa said, in which you would run us through everything as if you're starting anew, and then we could move on with it, and there could be a vote before I even left my select board office. But I don't have the studies, so we can't reconstitute the board. So I hear what you're saying, but we also have been waiting for over 6 months for those studies. So
Yeah, but just
there's
remember,
that as well.
we also need to remember who kicked the can down the street first.
Uh.
The continuation,
Hey, hey, hey.
Folks,
Folks,
please,
Please.
thank you.
the first continuations were by the town.
And we continued them to hear the public out.
That's right, because
Because they have
each
a
time
right
we
to
came
speak.
back, we were asking for something a little different. So that's all I had to say. Thank you.
Thank you.
Thank you.
Attorney Costa, so to
Yes.
answer Mr. Tromke's question, if a board member on the next board does miss 2 meetings or more than 1 meeting, they would have to spend 1 meeting reconstituting the board again, right? Because that's the law. But then they could continue with the hearing.
Correct. I mean, this is just a reality of municipal government, and it is particularly difficult in communities with 3-member adjudicatory boards. Sometimes it's a select board, sometimes it's a zoning board of appeals, where a unanimous vote of all 3 members is required to grant a special permit in particular, but also a variance for that matter, or to issue an administrative appeal reversing a building commission's determination. All 3 of those forms of relief require unanimous votes of 3-member boards. And so I appreciate an applicant's frustration. I don't know that I appreciate Mr. Tromke's frustration here, because I think these circumstances are egregious, and the board has been asking for something repeatedly from the applicant that hasn't been produced. So I'm not sure here that the party in the wrong is the board. It's also should be noted that the reason why a member of your board is ineligible to vote is not because that member chose to not come to meetings voluntarily, but because he wasn't elected to the board until this process was already underway.
Yeah.
And so it is what it is. It's unfortunate when this occurs. Could it happen again? It could certainly happen again when all 3 members are needed. If any one member misses 2 meetings, whether that's because they're just not showing up at the meetings, or they get ill, or something unexpected occurs, what can you do in those circumstances? You reconstitute the board in the manner that I described. Or it's a costly exercise, because when you reconstitute, you have to republish and renotice to a butter, so there's a cost associated with that. But in terms of timing, it doesn't typically cause much of a delay in the process, because you simply re-advertise and renotice between meetings when you'd be continuing the matter from meeting to meeting anyway. So that's what you would need to do in the future if this occurs again.
Thank you. Yes, you can come up and speak.
Good evening. I'm Attorney John McLaughlin from Greenmouse Lipton, representing multiple neighbors. I would wish you would at least consider that this withdrawal be with prejudice. As you heard Brother Counsel Costa say, he said, well, in 6 months and 3 hearings, this could be done. I was here. We had 3 hearings. We had 6 months. The applicant came here with nothing. I mean, the applicant should have come with all these reports in hand. We talk about modeling. I had to do modeling for a dog kennel. Sonic modeling for a tiny dog kennel, and came to it at the board. And the board didn't have to tell me to do it. And they say they have trouble getting experts. I have a case in land court with one of the major utility companies. I couldn't find a structural engineer. I had to go to Hartford. Sometimes if an applicant is serious, and this is different because the scope of this project is much larger than all the others. So this applicant had half a year, 3 hearings. He could have had 4 or 5 if he wanted it, but he didn't have everything ready. He applied with nothing. It's outrageous to blame this board. I mean, the applicant had half a year. He had from December of 23 to May of 24. We had 3 hearings. Excuse me. He didn't have anything. They made statements, we've met the criteria, saying that because they say they've met the criteria, they've met the criteria. They had no evidence for it. Again and again and again. It's not your fault. It's the applicant's fault. And to say that it should be with prejudice would be perfectly reasonable in this situation. They had half a year with the prior member. They had half a year. They had 3 hearings. I was here each time, and they didn't have anything. They came to you basically expecting you to give them the grant of the zoning relief without evidence, simply because they say everything's going to be okay. That was the substance of those first 3 hearings. You were here. I kept saying, this is outrageous. You should have sound studies. You should have particulate studies. You can't just come here and say, give me the permit because I want it, and I can get a permit in this district, so give me the permit. That was essentially their stance. If anyone deserves to get a withdrawal with prejudice, it's this applicant. That's all I want to say. And thank you.
So with that said, the board needs to make a vote on what's going to occur. So keep in mind again, Mr. Attorney Costa, I just want to make sure, if we do a withdrawal with prejudice, they're going to rescind their withdrawal, reconstitute the board again when the new members come in, and it's just a bunch of waste of time in the meantime, and money, because we are paying town council every single time this occurs.
Right, so I'm looking at the email that was submitted by Attorney Berthium, and I'm just gonna read the sentence toward the end of the email that addresses the alternative request. So it asks for a withdrawal without prejudice. And then it says, in the event that the board is not so inclined to grant our request, then I would ask in the alternative that the hearing be further continued in order to allow the board to be reconstituted by renoticing and publicizing the public hearing in order that a quorum may be reached. And he means a voting quorum.
Okay.
So do you have the option of withdrawing with prejudice? I suppose you do. You have the discretion with respect to this application. And so you could have closed the hearing months ago and voted to deny the project. My recommendation as your counsel is, if you're going to do that, if you're going to deny the project, and I don't know that you are, but if you're going to deny the project and you want that denial to withstand a challenge, you want to be best positioned to have a basis for that denial. And so I think that denying with prejudice at this stage in the process, it has the same effect allowing for withdrawal with prejudice has the same effect as a denial. And so if that then gets appealed to court, now the matter's out of your hands and it's in the hands of a judge. And it's in the hands of a judge without the benefit of you receiving the reports you requested and having those reports peer reviewed. If you want to deny it once you do all that, because your peer review consultants say noise is going to be a problem, particulate matter is going to be a problem, environmental issues are going to be problems, well, then you've got the grounds for denial. Or maybe conversely, the peer reviewers say that those things aren't going to be problems or that they can be adequately mitigated, and maybe then that's the support for you approving the project. But I appreciate Attorney McLaughlin's argument, advocating for his clients, for some of the neighbors, and saying withdraw with prejudice. I don't actually think that puts those who might want this project defeated in as good of a position as they think it will. It just takes the jurisdiction and discretion away from this board and puts it in the hands of the judge in Boston, for all we know, because it could go to land court, which is 100 miles away, and somebody who doesn't know the ins and outs and the particular concerns of the town of Granby. So that's what a withdrawal with prejudice does.
Thank you.
Yes.
Great.
With that said, I will make a motion to withdraw without prejudice,
To accept.
to accept,
Yeah.
to accept withdrawal without prejudice.
I'll second the motion.
Any further discussion?
No discussion.
All in favor?
Aye.
All right. So that's all we had on the agenda today. Thank you so much, Attorney Costa, for everything.
Thank you.
Thank you, Adam.
Thank you.
Now I will take a motion to adjourn the meeting, or the hearing. Do we have, yeah, we have to close. We close it now, right? Or no?
But I really.
That should have been a question for motion.
Well, it's over.
Yeah, it withdrew. Okay. So
Motion to adjourn the meeting.
Second the motion.
all in favor?
Aye.
Aye.